anyone could make a phone call, make an allegation, cops go boom and just stop, do whatever they want without.
Yes, Your Honor. The officer arrived and he observed a car which matched the description that the caller
That would be
gave.
like me calling and saying, hey, this guy did this over there. The cops go, no.
A man in Harris County, Texas, was pulled over in his Mitsubishi based on a vague caller's report of a disturbance at a Holiday Inn. Under Texas law, an officer must have reasonable suspicion based on specific, articulable facts to initiate a traffic stop. The stop relied solely on an anonymous tip without clear evidence of a crime. The driver admitted to a prior dispute but explained he was leaving to calm the situation. The officer's claim of intoxication, citing glossy eyes and alcohol odor, sparked concerns about the stop's legitimacy.
You're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. Officers were dispatched to a Holiday Inn in Harris County, Texas in response to a disturbance. The caller reported that 2 white males left the property, one in an F-150 and one in a Mitsubishi. When the officer arrived, he observed a Mitsubishi which matched the description given in the parking lot, headed toward the nearby road. The officer initiated a traffic stop and made contact with the driver, the defendant. Officer asked the defendant if he was involved in a physical disturbance, and the defendant stated yes, that him and another individual got into a physical fight, and that he got into his car to separate himself and calm down. The defendant stated he was headed toward a gas station when he was stopped by the officer. While speaking to the defendant, the officer observed an odor of alcoholic beverage, glossy eyes, and slurred speech. The defendant admitted to drinking 2 beers, and standard field sobriety tests were conducted. A 6 out of 6 on the HGN, a 0 out of 8 on the walk and turn, a 0 out of 4 on the one-leg stand. The DIC was read and the defendant consented to a breath test. The results were a .103 and a .113.
Judge, I'm going to say no probable cause here because...
What's he doing wrong? He's like trying to get away from him. He's like doing the right thing. You know?
And probable cause doesn't exist. He's 0 for 6 on the walk and turn, 0 and 6 on the one-leg stand. There is no law in Texas that a person cannot drink. Just because he smelled alcohol does not mean the person is intoxicated.
Do we have anything that he's doing, you know? Tell me what led them to him.
Yes, sir. So what led to the investigation was a caller who reported the disturbance. The officer arrived and he observed a car which matched the description that the caller
That would
gave.
be like me calling and saying, hey, this guy did this over there. The cops go, no. Theoretically, would be anyone could make a phone call, make an allegation, cops go boom and just stop, do whatever they want without.
Yes, Your Honor.
No probable cause.
Thank you, Judge.
Be careful, man. There's a lot of haters out there. Don't let them get you, you know? Life's too short. All right? All right. Good luck, friend.
Can I say something here?
Don't, Mr. Carruthers. Don't. Don't. Are you losing? Are you losing?
No.
Then stop.
In this gripping case, Judge Fleischer's meticulous scrutiny dismantled a flawed DWI charge against Mr. KS, showcasing the judiciary's power to curb overzealous policing.
Carruthers?
Yes, Judge Hexter.
Ronald Carruthers, come up. Mr. Carruthers, you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On March 2nd, 2024, officers were dispatched regarding a major crash in Harris County, Texas. Upon arrival, the officers made contact with the wheel witness. The witness observed the defendant's 2005 gold Chevy strike an unknown person riding a bike with his vehicle.
Whoa.
Yes, Your Honor.
Struck a person?
Riding a bike. Yes, Your Honor.
Okay.
The defendant then got out of his vehicle and began assaulting the unknown person and then drove away from the scene.
Whoa. You're telling me he strikes someone in a car and then on top of it starts assaulting this person?
Yes, Your Honor. The unknown person fled the scene, and the defendant was promptly found by officers 1 block away in a private driveway. That was not the defendant's residence. Upon contact with the defendant, the officer observed an odor of an alcoholic beverage, slurred speech, and
Poor balance.
poor balance. The defendant was detained. He refused SFSTs. The DIC was read. The defendant refused to provide a specimen. A blood search warrant was signed and executed. He was identified by his Texas driver's license.
I have just so many problems with this.
So, Judge, we have been unable to locate the unknown person that was on the bicycle. He fled because he was getting assaulted. We have no way of finding him.
Not only that, how do I know he's not consuming anything after the fact? How do we know he doesn't go home and chug a fifth of vodka?
The DIMS does say he was promptly found by the officers 1 block away.
I get it. I get it. Promptly is a conclusory word.
I'm pulling up the OR right now, Judge, to see if they have anything more specific.
Can I say something, Your Honor?
Don't, Mr. Carruthers, don't. Are you losing? Are you losing?
No.
Then stop. Anything else? Was that it?
Looking at times, Your Honor, to see if we can establish when he was found based on when he was dispatched. I don't think we have anything additional, Your Honor.
It says, yeah.
Mr. Carruthers, I'm going to find no probable cause in your case. You know, we have enough death. We have enough dismemberment. We have enough blood all over our streets. Please don't add to it. Please just don't kill someone. That's all I'm asking you to do, man. You know, $40. An Uber will take you anywhere you want to go in this county. Anywhere. Please, don't kill someone. Take a seat, please.
The Fourth Amendment protects against unreasonable searches and seizures, ensuring officers must substantiate probable cause with concrete evidence. The prosecution's failure to locate the alleged victim and reliance on vague observations like odor of alcohol and poor balance crumbled under the judge's probing. Without specific timelines or a victim's testimony, the case lacked the substance to justify detaining Mr. KS. Judge Fleischer's ruling not only freed an innocent man, but also sent a resounding message to law enforcement. Power must be exercised with precision, not presumption. His poignant plea, "Please don't kill someone," underscored the human stakes of such cases, urging responsibility over recklessness. This case stands as a testament to judicial vigilance, triumphing over hasty police action, preserving justice in Harris County.